Welcome back to my ACCA Law revision series. I'm CA Tanya Kakkar, and in today's lecture, we are kicking off with one of the most scoring areas of the law paper: how the UK law actually creates and applies law. I'll break it down in a way that it makes the entire structure effortless to remember, so you actually understand the logic behind it. If you have ever been confused about parliament, delegated legislation, court, tracts, or judicial precedent, this session will make sure that everything is very clean for you all at once. So let's get started. In our yesterday's lecture, we discussed how legal system works and what are the three different types of legal systems, where we discussed about civil law, criminal law, and common law. We discussed what is criminal law and how does that work, and when does criminal law comes into picture, how do you differentiate a scenario between that relates to a criminal law and which scenario that falls under uh, our civil law. We discussed the purposes. We discussed that burden of proof is on state always whenever there is a case law against. In case of criminal law, it is stated as state versus so and so person. The standard of proof must be 100%. The standard of proof must be 100%. Basically, you should not have any reasonable doubt of on the accused guilty person. The objective is to make the society more disciplined, and we discussed that usually the outcome is, if found guilty, there can be a fine, imprisonment, or both. In case of civil law, it is more kind of a private law. It is between two individuals. A dispute is between two individuals. The principles of civil law is comprehensibility and certainty, where there are broader general principles that applies to various situations. The burden of proof here is usually on the claimant, that is the person who is bringing the case, and the defendant is the person against whom the case has been brought in. The standard of proof is 51% or more. I'm just giving you the numbers. Please make sure that you are not uh, this is not the way that it can be asked in MCQs. Basically, all I'm trying to explain is that standard of proof in case of civil law depends upon probabilities. The objective is to restore or to compensate the person, or to bring that person in a financial position that they would have been had they not been entered into the contract. Then we discussed about conflicts of law. Usually conflicts of law happens, and that is why we are studying international law. Then we discussed about common law. It is kind of an old kind of a law where law was not actually explicitly written down or so, but it depends on the situations and the judgments that judges used to pass. A few core principles were that it does not get irrelevant with time. Just because a new law is made, that doesn't mean that it has destroyed the old law, and they exercise the law and use judicial precedent that we will be discussing in either today's lecture or tomorrow's revision lecture. Usually in common law, the roles of judges are to apply law and sometimes to even interpret the law. Now, in today's lecture, let's discuss how law is made in UK. All right. So the entire lawmaking authority is with the UK Parliament, and the lawmaking authority, that is UK Parliament, has divided into two branches. The one is legislation and the second is delegated legislation. The very first branch is legislation, that is the primary branch of making law, where important laws are made by the Parliament, House of Commons, House of Lords, and Royal Assents. Usually, the purpose of legislation is to make important laws such as taxation, new laws, or to overrule a precedent. Precedent basically means a old judgment or a previous law. So the legislation, the legislation, that is the primary lawmaking, is done by parliament. Here this legislation council, you can say, basically in these branches there are set of people who sit or come together and make law. This is created, the first branch is created by parliament. Common laws that include royal assents, lords, commons, etc. And the purpose is to create new laws, taxations, to codify, consolidate laws, and to overrule any precedent. The delegated legislation, however, have a few branches to it. The very first branch of delegated legislation is statutory instrument, where detailed rules are made by the government and ministers. See, government and ministers and everyone is sitting there, but you cannot expect them to also run the country, or to also look after the affairs of the country, and to also make rules and regulations. All right. And that is where there are people that have been seated or selected by them, who have the right to make law. And in this particular scenario, that is statutory instruments, here people actually go in detail, analyze various situations, and then they make law. Orders in council, this particular branch under delegated legislation is to be used only in case of emergencies. If in case any law is to be made at the time of emergency, order in council is the right committee, you can say, or the right people who make law in the time of emergency. For example, if I take in case of COVID, suddenly there were lockdowns implemented, there were so many restrictions implemented. In fact, um, if I'm talking about country wise, definitely, but in fact globally lockdowns were implemented, correct? So how did that came into picture? How suddenly such rule rolled out so drastically and so fast, that it was implemented in a day's time or so, because there were separate set of people who have already been selected, as always, who makes law in case of emergency situations. Professional regulations, these professional regulations usually make rules and regulations for uh, you know professional societies, like let's say a law society that contains of lawyers only. A few rules and regulations were supposed to be made only and only for those people. Let's say we are future ACCAs. There are many rules and regulations that applies to just us, and not a people, or common people at large, because we are a very financially well individuals. We cannot say financially well, sorry, my bad. But we are kind of we have that kind of power to interpret the finance, or to interpret law, or to file taxations of so many people who does not understand these rules and regulations very easily, or very, it is not very easy for them to understand. Just because we understand, that doesn't mean that we take an undue advantage of it. And to avoid that, there are so many rules and regulations that applies to just us as an ACCA individual, or even to maintain that professionalism, there are rules and regulations that are applied. So who makes those rules and regulations? Under delegated legislation, the professional regulations committee, or a place is where such rules and regulations comes into picture. Court rule sets, if you would have ever seen, there are a few rules and regulations that apply only and only into the courtroom, that does not apply outside the courtroom. Let's say if I take an example of India, usually, or even in many countries, if I say, usually as soon as judges enters, people sitting are supposed to stand up, and once the judges sit, you are supposed to sit down. That is not out of a respect, it is also a law that usually people follow under courtrooms. Usually when judges say, silence or order or so, people are supposed to follow that. If you don't follow that, you can be taken into prison or there can be fines implemented on you, because it would be termed as you are breaking a law. And then there is bylaws, where local rules are made and applied locally uh, by authorities, that is limited to just that particular area. Also, let's say in India, in case if we are talking about Gujarat, it is a dry state, but that rules apply only and only to that particular state and not to the entire India. I hope lawmaking in UK is very is like clear to you guys. I have made this chart. If you still want a clear version of the entire PDF, you can let me know in the comment section and I will make sure to forward it to you guys. So, lawmaking in UK, there are two branches, legislation and delegated legislation. In case of legislation, important rules and regulations are made here. In case of delegated legislation, law made by bodies authorized by parliament to save time and deal with it in detailed manner. So basically, delegated legislation is made to deal with situations in detailed manner, and hence there are five branches to it, and each branch look into separate set of rules and regulations. Like statutory instruments makes detailed rules, order in council makes rules during emergencies, professional regulations make rules for professional individuals or a group of professional individuals. Court rules are that are the ones who make rules for procedures for courts under Major Courts Act, and bylaws are the committee who make rules locally that are applied or applicable locally. Now, let's understand UK judiciary. In fact, the court flow under UK judiciary, basically, how does court system works in UK? So, at the top, of course, this there is UK Supreme Court, the highest appellate court. Let's start from below. Basically, there is this one UK Supreme Court. However, in below courts level, all right, let's discuss about civil division. So this one is civil division and this one is criminal division. All right. So in case of civil division, county courts are the first instances for civil matters. So the very first court that usually people go to in case if there is any civil issue or any case that is a civil that comes under civil laws, usually people go to county courts. Case is discussed there, and whatever the judgment is passed by the judge. If both the parties are satisfied, great. If both the parties, if in fact any one party or both the parties think that this is not the right judgment or justified judgment for us, they have the option of going to high court. All right. In once in If the court is discussed, if the case is discussed in the very first time, case is discussed in county court, and if a proper solution is not given to the people, or people think that this is not the right solution, they have the option of going to high court. However, there are three branches in high court as well when we are talking about civil division. The first one is High Court, that discuss only family matters, that is family division, that discuss only matrimonial matters. The second is Queen's Bench, that discuss about contract and torts. Tort meaning doing a civil wrong. What do you mean by tort? Tort basically means that in case you are doing any civil wrong, you are supposed to, or if you think that any civil wrong has happened, you are supposed to go to Queen's Bench when you're going to High Court. And Chancery, usually whenever there is any case regarding land or revenue, people go to this particular branch. So if you want to go to High Court, you would have to first see whether you would have to go to family division. If in case if your matter is matrimonial, you would have to go to Queen's Bench if your matter is related to tort or contracts. And you would have to go to Chancery division if it relates to land or revenue. The example that we took yesterday about contract between Mr. X and Mr. Y, that Mr. X was supposed to give goods and Mr. Y was supposed to pay 10,000 rupees. In that particular case, that is a contract. And let's say Mr. Y goes to county courts first and does not get a satisfactory judgment or decisions by the judges. He has the right to go to High Court under Queen's Bench. All right. Then, however, let's say the case was discussed in High Court as well, and Mr. Y still thinks that this is not the right judgment, or not, this is not justifiable, this judgment is not justifiable for me. Mr. Y still has the right or an option to further take their particular case to Court of Appeal, where they can appeal from courts, county and high courts. Basically, they can file for an appeal where any decision that has been passed by county court or high court, they can go to Court of Appeal and ask or appeal the judge that this is not the right decision for me, and I just don't think that this should have happened, or this is something that has happened wrong with me. However, if you are not even satisfied by the judgment of Court of Appeal, then you can go to Supreme Court. Supreme Court is the highest appealing court. That is the last place where you can go and file an appeal. And whatever decisions made by Supreme Court are final and binding. All right. So this is all about civil division. Let's also discuss about criminal division. In case of criminal division, you are first supposed to go to magistrate's court in case of minor offenses where the offense is criminal but it is a minor offense. You can go to magistrate's court. However, if it is a serious offense, you can directly go to crown courts. All right. So if it is a minor offense, you can go to magistrate court. However, if it is a serious offense, you can go to crown courts. Any decisions passed by these courts, if you feel that this is, if the party feels that this is not right or not, the justice has not been served, they can go to Court of Appeal. That is in criminal division, Court of Appeal, that means appeal from crown courts. Wherever there is an appeal from crown court, you can take it to Court of Appeal and then you can go to Supreme Court. In case of Supreme Court, there are no two separate divisions. Even civil cases related to civil law or cases related to criminal law are supposed to go to this just one UK Supreme Court. However, the below courts are distributed between civil and criminal division. All right, this entire chart I have curated for you guys. You can take a snap of it as well. However, I've summarized this in a very, very good form. You can just have a look at it just one day before your examination, and you will be good to go. You will know the level of courts or the hierarchy of courts, and you will know at what court you are supposed to go when there is any particular issue. So there might be chances that a MCQ is in a scenario based, and they are giving you scenarios and then they are asking, tell Mr. Y the right court where he can go for appealing or where he can file his particular case. All right, so such scenario based questions can definitely come in examinations. So this is just one concise chart that you have to look for and you are good to go. Again, I'll repeat because it is important. you can mark this one as important as well. So, if we talk about hierarchy in case of civil law, or in case of any civil case scenarios, when we are talking about civil division, it is county courts, then high court. High court has three branches. The first one is family division, the second one is Queen's Bench, the third one is Chancery division. Then, in case above high court, there is Court of Appeal, and then UK Supreme Court. When we are talking about criminal division, the first one is magistrates court, where there are minor offenses discussed. The second one is crown court, where serious offenses are discussed. Then there is Court of Appeal, and then there is UK Supreme Court. I hope this chart is clear to you guys. Now, courts have tracking systems, or the right word is three track systems. In case of civil courts, have three track systems. Basically, your case laws are divided, or based on complexity and value of the case. Where civil claim is filed, court assigns it to one of the three tracks based on value and its complexity. The small claims track, where disputes are somewhere up to 10,000 pounds, they are very informal, very minimal procedures are uh, to be followed, and there are no lawyers involved. Let's say if you're filing a case, that is, in our example, Mr. X and Mr. Y, it was up to, let's say, 10,000 pounds. In such scenario, it will go to small claims track, which is a very small dispute. For it to be a fast track, it should be between 10,000 pounds to 25,000 pounds. Just a second. Yeah. So for fast track, the claim should be between 10,000 pounds to 25,000 pounds. So let's say in our case, in the first case scenario, it can be up to 9,999 pounds. However, if it is 10,000 pounds up and up to between 10,000 to 25,000 pounds, it will be a fast track. It is designed to be completed within just one day. It is more structured than small claims, but still streamlined. And then there is multi-tracks for claims over 25,000 pounds or so, or any, if the case is very complex, then also, if the case is complex, it goes to multi-track. It is flexible, allows a proper case management. However, we discuss small claims, fast track, and multi-track. Small claims track, fast track, and multi-tracks. Usually, county court handles small, fast track, and multi tracks, and high court deals with complex or high value multi tracks. All right. So all these tracks are handled by the county court, that is the first instance. However, if it is very complex or high value multi tracked or so, then it can directly go to high court. All right. Is this clear? Up to, or let's say up to 10,000 small track, 10,000 pounds to 25,000 pounds fast track, 25,000 or above, or any complex multi track. In case of small claims, it is very informal. Fast track can be completed in just, should have been completed in just one day, and multi track, where it is more tailored and case management happens. Now, there are a few other codes as well. I'll just quickly cover that. The first one is European Court of Human Rights. It is a final court for matters under human rights. So you can go to this court only and only if the matter is as per human rights. A case reaches here only after all UK court options are exhausted. So we just discussed that UK Supreme Court is the last court that you can go to, and any verdict or any judgment passed by the UK Supreme Court is the final judgment or final verdict, and you are supposed to be bound by that judgment. However, if your case is dependent or has matter that falls under Human Rights Act 1998, then in such scenario, you even after fighting in Supreme Court, you can go to European Court of Human Right and file a case law, and the decision by them are final. No further appeal is possible. The Judicial Committee of Privy Council, what is JPC? It is a final appellant court for Commonwealth nations, crown dependencies, and UK overseas territories. So even after fighting in Supreme Court, and if the case is between Commonwealth nations, or it is a crown dependencies or UK overseas territories, you can go to JPC. They handle both civil and criminal appeals. The right appeal depends on each country's constitution and laws, because there here we are talking about international law, so it depends on each country's constitution and law. Hearings are held in UK Supreme Court building itself. Mark my words, hearings are held there. It does not mean that hearings are held in UK Supreme Court. In the building where UK Supreme Court exists, the JPC court also, the JPC council also exists, and hearings are held there. And in this case also, the ruling is final, that is the judgment passed in final, and no further appeal can be done in JPC as well. So these are a few other concepts that are linked to court systems in UK. Now, let's discuss another small topic and then we will be done for today's lecture. Let's get started with doctrine of judicial precedence. If you remember, in our last lecture, we discussed about doctrine of judicial precedent, and I said, sorry, that I will be covering that topic in our upcoming lectures. When we were discussing about common law, here we discussed that judges must exercise judicial precedent. Now, what do you mean by judicial precedent? If you go through my last lecture, we took an example where we discussed that Mr. I'm not sure what are the names, Ram and Sam. Yeah, right. If you remember, we discussed that there was this farmer named Mr. Ram and the other farmer named Mr. Sam. They both had two cows individually. So Mr. Ram had two cows and Mr. Sam had two cows. One fine day, cow of Mr. Ram goes into the farm of Mr. Sam and destroys everything that Mr. Sam has grown in his farm. So the judgment, basically, when these we are talking about youth, like very very centuries back, so you cannot say judgment, but the final conclusion that came out of this entire case scenario was, or the verdict that came was, Mr. Ram was supposed to make sure that the cows are tied properly because they are the property of Mr. Ram, and he was supposed to make sure that some damage or any damage does not happen because of the cows. So as it was the responsibility of Mr. Ram, Mr. Ram is liable to pay all the damages to Mr. Sam. Let's say after a few months or a few years, again same instance happened with Mr. Steve and Mr. John. All right. So let's say again same scenario happens with Mr. Steve and Mr. John. At this point, people can look back to this instance or to this case and say that this was the ruling, or this was the verdict, or this was the final conclusion of this law, of this case, where to whom the cow belonged is the person liable to pay damages. I have explained you the entire concept of doctrine of judicial precedent. It basically means that judges follow decisions previously made. Basically, the decision that was previously made, judges just follow that decision. And that is And that is what has been happening in common law, and that is why equity came into picture, that we discussed in our last lecture. So, what is a doctrine of judicial precedent? You are looking at a previously made decision or judgment. It is a system where judges follow a decision passed that was previously made in a similar case by a senior or equivalent court. When I am talking about either a senior or equivalent court, meaning being county court is looking at decision made by either court of appeal or high court. All right. Or let's say the court of appeal is looking at the decision made by either UK Supreme Court or court of appeal themselves. All right. So it means either previous courts, and the case has to be similar. Okay. Some precedents are binding and some are persuasive. What do you mean by that? A few decisions previously made are 100% binding. However, a few are persuasive. That means judges have a choice whether they want to follow it or they don't want to follow it. That is completely at their discretion. The application of consistency is based on judicial precedent. However, there are a few rules that you have to follow if you are following judicial precedent. A precedent must be based on law and not fact. The very first rule, let's discuss the rules. There are 5 rules that you are supposed to follow if you are following judicial precedent. The very first rule says that it should be based on law and not a mere fact. All right. So a decision binding is binding only found in a point of law and not a unique factual circumstances. So that means, let's say, any unique circumstances would have appeared in particular case, and a separate judgment would have been passed. Judges cannot look at that case because it was based on facts and not laws. Many a time judges passes judgments that are not merely based on law but also based on facts. In such scenarios, you cannot follow doctrine of judicial precedent, or that means you cannot look at such scenarios where decision were passed based on looking at facts. Okay, so you're supposed to pass, or you're supposed to look at only on and only those cases where decision was taken based on law. The second rule is it must come from a superior court. Lower courts are bound only by precedent set by courts above them in hierarchy. What do you mean by that? If in case High Court wants to pass any judgment based on doctrine of judicial precedent, basically based on any case law that has been previously happened, High Court can look up only and only judgment passed either by Court of Appeal or by Supreme Court. High Court cannot refer to a court's judgment that has been passed in county court. Okay, so that is why understanding the hierarchy is also important, because if you want to follow judicial precedent, that the verdict or the conclusion or the decision must come from a superior court and not a court that is below you in the hierarchy. Let's say for high court they cannot follow county court. Let's say for court of appeal they cannot follow any decision passed by high court or county court. Material facts must match. What do you mean by material facts must match? In let's say Mr. Steve and Mr. John, they also had, let's say Mr. Steve had 1 cow and Mr. John had 2 cows. All right. However, again this cow went to the farm and destroyed everything that Mr. John has grown. In this entire scenario, even if in this case there were 2 cows, here it was 1 cow, this is not a material fact of the case. The material fact of the case is the cow going and destroying the crops. So material facts of both the cases must be same, must match, then and only then the judicial precedent decision can be applied, can be overruled by a higher court. What do you mean by that? any decision, let's say a high court looks at a decision passed by court of appeal and passes the same judgment or so. However, people go to Supreme Court. Supreme Court has the right to overrule the decision or to overrule the judicial precedent, which means that Superior Court may overturn the precedent, removing its binding effect. They can basically altogether discard the decision that has a binding effect. Supreme Court can overrule itself, which means that if any judgment is passed by Supreme Court has the right to overrule or basically to scrap its own judgment. These are the five rules that you have to follow, or that judges usually have to follow if they are following or passing any judgment or taking any decision based on judicial precedent. The very first is it must be based on law and not facts. It must come from a superior court. Material facts must be same, can be overruled by a higher court, and Supreme Court can overrule itself. I hope this is very clear. The doctrine of judicial precedent is clear to you guys. That's it for today. If this has helped you to get clarity, the next lectures will make sure that the entire subject is even easier for you. We'll go step by step through exam style questions and exact logic that examiners expect you to apply. Stay with the series because once you understand the system, every chapter that follows becomes 10x simple and your MCQs start falling into place. Thank you for today.